The Delhi High Court will pass orders on Future Retail's petition against enforcement of a Singaporean arbitral award which had halted the sale of its retail assets to Reliance Industries. Amazon had opposed this deal worth 24,713 crores, which was approved by the Competition Commission of India on the 20th of November. Future Retail had told the High Court that over 10% investment by Amazon would have violated FEMA rules, claiming that their deal cannot be controlled by a foreign investor who cannot acquire controlling stake in Indian multi-brand retail as per law. They likened the conduct of Amazon to East India Company and claimed that it was destroying competition in Indian market. On the other hand, Amazon had urged CCI and SEBI to not allow Reliance-Future Group deal and had requested SEBI to probe the deal between Future Group and Reliance. Amazon claimed that Future Retail had engaged in insider trading and claimed that as per law, the Singapore Arbitral Award is binding in India unless set aside by a court of law. They also claimed that Bianis were a willing party to Singapore arbitration and cannot refuse to honor the award now. They also claimed that they would have never allowed Future Retail to sink, but they had breached the written contract by dealing with Reliance. Reliance Retail, on the other hand, likened Amazon's conduct to a dog in a manger, stating that they were neither helping Future Retail nor letting it seek funds elsewhere when it was aware of the company's precarious financial condition. Appearing for Reliance Retail, senior lawyer A.M. Singhvi accused Amazon of a U-turn before SEBI and CCI. He alleged that Amazon had told CCI they invested only in future coupons, but told SEBI that the transaction was integrated for Future Retail. Future Retail had argued that Amazon's attempt to control its transactions were violative of FEMA regulations. Appearing for Future Retail, senior lawyer Harish Salve argued that the company's fortunes had tanked due to the lockdown and it would have gone bust if money was not put in. Future Retail had urged the High Court to restrain Amazon from writing letters to SEBI and CCI and to allow execution of its deal with Reliance Retail. They had urged the court to stop the American giant from killing an Indian company to further its design, claiming that they were trying to force Indian authorities to implement an emergency arbitration order which was not enforceable in India. They also contended that Amazon was misusing Indian law, while Salve submitted that an unrelated arbitration order cannot be used to subdue Indian public policy, which does not allow foreign direct investment in multi-brand retail. Salve stated that Amazon knew that Future Group's promoters, Bianis, were in talks with Reliance Retail for funds to survive the lockdown. He pointed out that Amazon's claims of right to control Future Retail's deals are violative of FEMA regulations, and a foreign arbitral order cannot decide the fate of an Indian company on an agreement it was not a party to. Arguing for Future Coupons, senior lawyer Mukul Rohtgi maintained that the emergency arbitration is a complete nullity since it is not recognized as per Indian law. Amazon had opposed identical arguments by Future Coupons, Future Retail and Reliance Retail. Appearing for Amazon, senior lawyer Gopal Subramaniam pointed out that both Future Coupons and Future Retail were controlled by Bianis, claiming that the arbitration award was binding since Indian law allows arbitration agreement agreed to by the signing parties, claiming that the Future Group had willingly argued as one entity before the Singapore-based arbitrator.